well, after I get done with it. The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this fashion due to the ongoing pandemic. Although we are conducting court in this way, all the ordinary rules of oral argument apply, including that each side receives 15 minutes to argue with no rebuttal. This morning, it's my great pleasure to be sitting with Justices Henry and Justice Singh, and my name is Gabrielle Wolohojian. With that, I'm going to call the case of Commonwealth versus Ryan Anderson, number 2019 P 1719. Attorney Del Signore, we're ready whenever you are, and Attorney Levin, if you wouldn't mind putting yourself on mute. Thank you.
Good morning, Justices. Thank you so much for the opportunity this morning. May it please the court, Tony Del Signore for Mr. Anderson. And I just want to begin, obviously, with the motion in limine, but specifically, to tie that into the materials that this court requested prior to the oral argument. So the judge's ruling, beginning to end, was he agreed to test, motion denied. And that was really the end of her analysis, beginning to end. So that really is an error of law, because the case law makes very, very clear that an initial agreement to test does not negate a subsequent refusal. And now going to the motion
question.
Sure.
About that. Why does the reason let's just stick with the motion in limine for the moment.
Sure.
Why would the judge's reasoning matter? Is our review de novo?
Well, in terms of the application of the constitutional principles, yes, it is. And that standard, I believe, is mentioned I believe it's in Grenier, but that's just in terms of the general principle that application of constitutional principles.
Right. And to the extent that, then do you read the judge's decision as being a legal one or a factual finding?
Well, I think that's her rationale. I mean, I think, and even looking specifically, I know that she has the marginal notation and she has her oral ruling that's reflected in the transcript. But if you look at what's reflected in the transcript, she says, so since he agreed, this motion is denied. And I would suggest that really represents legal reasoning. That's the reason that she gave for denying the motion. And that's really what I'm saying is the error of law, because that reasoning is not sufficient to deny the motion. Going to the police report, she and what was in the motion, quote, I'm actually quoting from the motion, but which is obviously quoting the police report. I placed Anderson in the starting position and began to explain the walk and turn test. Anderson could not stay in the starting position and began to shake his head and stop listening to my instructions. I asked Anderson to go back to the starting position and started stumbling around the area, shaking his head. That's twice just in the quoted portion there that the trooper Page is referencing, he's shaking his head. He's saying no. And what I'm saying is, given what was in front of the judge
How do you get to the he's saying no?
I apologize, Justice Wolohojian.
How do you get to the he's saying no?
Oh, I don't literally mean he's saying the words no. I'm saying shaking your head. Right. I don't see that that's susceptible. I'm sorry, I see your box light up. I don't want to cut you off.
Do you think that that's susceptible to some kind of interpretation that's a factual matter?
I think him shaking his...
I know, but it's not about what you think or what I think.
I don't think shaking...
In other words, the police report doesn't say he shook his head indicating no. It doesn't say that. It's right.
Right, but the standard is objective, and I think objectively, shaking your head, I objectively, I don't think that's susceptible to any meaning other than No. For example, if someone said, if just to change the facts, if Trooper Page had said, do you want to take this test? And he went, that's not susceptible to any meaning other than no. And based on what's in the police report, that's really what's suggested. He's giving the instructions and Mr. Anderson starts shaking his head. And again, because the standard is an objective one, objectively shaking your head is just not susceptible to any meaning.
What if, because it seems to me that we need to look at the context in which the head shaking takes place. So
Sure.
Unlike in your example where someone shook their head in response to a yes or no question, that's not what happened here. He was shaking his head while performing something physical. Why is it that in those circumstances that couldn't indicate, for example, frustration?
Absolutely, I understand your question, and to ground it in the context, to sort of rewind the clock a little in the police report, he does the horizontal gaze nystagmus test. He listens to those instructions. He indicates that he understands the instructions. He completes the test, okay? And then moves on, listens to the instructions and begins to shake his head. I mean, I agree with you, Justice Wolohojian, that certainly shaking your head could indicate frustration, but it indicates, if anything, frustration. I mean, the two concepts aren't mutually exclusive. Certainly his frustration might be the reason why he's refusing, right?
Sure.
So
but
I don't.
All of those, why aren't those factual determinations that can't be made here? In other words, someone needs to sort this out as a factual matter. What was the significance of his shaking his head?
Sure. And I just think in this particular case, the judge, I mean, the judge certainly didn't make a determination. And I think based on what's in front.
So is the proper solution a remand?
I mean, are you saying a remand for factual findings?
Yes.
I don't believe so, because I believe that based on what was in the motion and what was in the police report, and then subsequently what came out at trial. I mean, what came out at trial was sort of even went beyond what was in the motion. So I don't think a remand for factual findings would be sufficient because of what came out at trial. What came out at trial was, again, went beyond, the troopers testifying to statements that Mr. Anderson made. So, at that point, going back to make a determination based on the police report, I don't think would cure the issue.
So counsel, who has the burden of proof on this issue?
Well, so in terms of the
in
error,
terms of withdrawing the giving of consent.
In terms of withdrawing the giving of consent, I guess what I'm. I mean, sir, in terms of withdrawing the giving of consent, I think even if it is the defendant's burden to show that, the judge never considered it. I mean, the judge never even reached the issue of whether he withdrew the consent, because her analysis was he agreed to test, and that basically negates everything that happened afterward.
Well, but to follow up though on Judge Wolohojian's point, what we have here is one witness, the trooper. Let's credit everything he says. And he says, on the one hand, the defendant says, I don't wanna, I'm not gonna. And the trooper also said, it seemed like he didn't wanna take part in the test. Okay. But on the other hand, the exact same witness said, he said, I can't. And he stopped midway and he just gave up on it.
Sure. But even in the context of that testimony, the statement, I can't, constitutes a refusal. This is not like Brown. In Brown, the defendant there was raising his foot. He was literally in the middle of doing the one-legged stand. He had picked his leg up, he put his leg down. He picked his leg up, put his leg down, said, I can't do this. Likewise, in the unpublished case, the Gregson case that the Commonwealth cited, same exact situation. The defendant there lifting his leg, putting it down, attempting the one-legged stand, and he said, I can't, or I won't. In this case, Mr. Anderson was not doing a test at all. There was no test that he was doing. He was standing there for some amount of time listening to the instruction. And then, yeah, according to the trooper's testimony, stopped listening, was shaking his head, was saying, I can't, I won't. So no matter what words you put to it, these aren't like, the Commonwealth is arguing, oh, these are expressions of difficulty. This isn't a refusal. You can't express difficulty with a test that you haven't done. Looking at Brown, someone looking at that defendant from a distance is going to say, oh, he's trying to do the one-legged stand and he's failing to do it. Someone looking at Mr. Anderson from a distance could not possibly have identified what test he purportedly was doing, because he wasn't doing a test. So for that reason.
Okay, so none of, I appreciate your argument, but what I'm struggling with is there's obviously no testimony to that effect, right? As to what a person, an objective bystander would have concluded from what the defendant was doing. What you're arguing, which is permissible, are the inferences that one should draw from the evidence that did come in. And I again struggle with who's supposed to make those inferences, if not the judge below.
Okay. So Justice Wolohojian, I agree certainly that some of what I was saying was inferential, but even backing away from what I was saying about in terms of what someone would see, there's no evidence at all in the police report or in Trooper Page's testimony. He never testified anything that would suggest that he had actually begun to do the 9-step walk and turn. He didn't, he never testified, oh, Mr. Anderson lined up at the spot where I told him to line up. He never took a step one foot in front of the other.
Counsel, I appreciate what you're saying, but I'm sure there's cases, but we've seen, after 5 years here, I've seen so many of these cases, and the troopers all testify that the instructions are part of the test, that they want I don't know whether this fellow testified to that, but they want to, it's a divided attention test. So they're giving them all these complicated instructions to see if they can stand still and then do all the things.
Absolutely, Justice Henry. But what the trooper subjectively thinks about what he's doing is not relevant. And the case law doesn't support the concept that the instructions are part of the test. And that's that's clear in McGrail and it's clear in Grenier, where in both of those cases, the defendants there listened to the instructions and then refused. And if it were true under this law that the instructions were part of the test, then I would suggest that those cases would have had to come out differently. And so I completely agree with you, Justice Henry, that certainly the trooper subjectively believes that that's part of the test, but for the purposes of the law of the Commonwealth, it isn't part of the test under McGrail and Grenier.
If I take it that there's no real disagreement that the evidence supported a conclusion that the defendant initially agreed to take the test. There was an initial agreement.
Yes, I don't think that was contested.
So what we're really talking about here is whether the evidence, and perhaps the evidence would have supported a finding either way, that he withdrew his consent, or he didn't really withdraw his consent. He was just expressing an inability to do the test. Who has the burden of proving, this goes back to Justice Henry's question, who has the burden of proving which of those two it was?
Well, it was Mr. Anderson's motion in limine to preclude the evidence. So I suppose it would be, his burden. But I would suggest that, he's met the burden. He's met the conduct in the police report more than amply suggests that he's refusing a test. Again, and I don't mean to go back to it, but he never began the test. So to say that he's expressing difficulty with the test, that's the line there, I think, is not one that we can draw. We can't say, well, to say he's expressing difficulty with the test, so he doesn't want to do it. I mean, to me, that's just another way of saying he's refusing to do the test. Anything that expresses an unwillingness to test prior to beginning the test is a refusal to test. Whether it's because he's frustrated, whether it's because he thinks, really,
All right,
the fact that
where time is running short. So if we were to agree with you that he withdrew consent, what do you contend should be excluded?
Sure. So I would contend that essentially all of the conduct, the shaking of his head, the walking around the scene while he's shaking his head, because I think that those two things, you can't separate them. The walking around and the shaking of the head that go together. And I, as I said in the brief, the quote unquote, the blading toward the officer is just another way of expressing, I am not going to do this. And frankly, it's the only thing.
I don't remember the specific. I thought they said he squared up and raised his fists. Would raising his fists be excluded?
Right. That's what they termed blading. And what I'm suggesting is that's just an extreme way of saying, I don't want to do this. In the context, he's saying, no, I don't want to do this. And I see my time's running out. If the court would just permit me to just finish the answer.
Yes.
Thank you. I understand that's an extreme way of saying, I don't want to do this. But in the context of what was happening, the trooper repeatedly, they talk about pushing him back into the area. Come on, do the test. And he's simultaneously saying, no, I don't want to do it. And finally, he says, I'm not doing the test. He right. Your characterization, I think, was accurate, Justice Henry. He squares up at the officer. But frankly, that's the only thing that actually got them to stop trying to make him do the test. So I'm suggesting that absolutely that is a testimonial communication that says, I don't want to do the test.
Thank you. Let me see if there are any further questions.
I just wanted to understand why you wanted us to read the Daigle case, which was the breathalyzer case.
Oh, so that was only for the prejudice prong, where in that case, one of the elements one of the reasons why there was prejudice in that case was because trial counsel had mounted a vigorous defense. And what I was trying to refer to is the fact that in this particular case as well, trial counsel really had a strong theory of the defense and really worked hard, introduced a number of exhibits and did a lot to try to suggest to the jury there are innocent explanations for every single thing that happened here. And where she did mount sort of a vigorous defense, I'm suggesting that the risk of prejudice was higher. And that's not on the facts for Daigle, but just on that concept.
Thank you.
Sure.
Good. Thank you very much. Attorney Levin.
Good morning, Your Honors, and may it please the court. Special Assistant District Attorney Stacey Levin on behalf of the Commonwealth, asking this court to affirm the defendant's conviction. Now, I'd like to start by reiterating Justice Henry's point that the test had begun when the instructions were given. I'd like to point to several places in the transcript that supports that position. First is at transcript 62. Trooper Page testified that he did, in fact, place the defendant in the starting position, which involved having the defendant stand with his right foot in front of his left with his hands at his side. Trooper Page testified that he could not maintain that position. He was stumbling and he could not stand in that position.
So counsel, though, we have statements going both ways from the same witness. So let's credit them all for the moment. And the same witness seems to have drawn the opposite conclusion from the statements too, saying at one point it seemed like he didn't want to, and at one point he just gave up on it. So I don't know how anybody makes factual findings when you have the same witness drawing these two things, but we do have this, I don't wanna, and I'm not gonna, and then I can't. Okay, so let's just simplify this. If the guy's still sitting in his car and the trooper says, would you get out to do field sobriety tests? And the defendant says, I don't wanna. Is that a refusal?
Yes, Your Honor. And that would fall under the McGrail and Ranieri cases where the defendant clearly created an expression of refusal, did not agree to test, and did not attempt to test.
What if he says, I don't wanna, I can't?
Well, Your Honor, then I would point your attention to the Gregson case that was included in our brief addendum, page 46. In footnote 2 of that case, this court noted that the context matters. And I believe that Justice Wolohojian noted this during my brother's argument. The context is important. And here, where the defendant had agreed to test and had started the test, those statements of "I can't" are expressions of difficulty. And even though a statement like "I don't want to" might sound like a refusal, as this court noted in that footnote, in the context of attempting the test and making other statements like "I can't," that statement is also interpreted as an expression of difficulty.
So obviously I understand that this trooper and many, many, many other troopers have testified that the test begins when the instructions begin. But if we flip over to, say, the lay public, like the defendant, they may not realize that the test has begun when the instructions began. In fact, I think many of them would have no idea that the test had begun. They would just think they were listening to instructions. So what standard are we using at this point? Whose point of view are we looking at? Do you know? Do you have a case?
Well, I would point this court to an unpublished case, Figuera, which I can provide in a 16L letter after this argument, where this court did note that at least for a walk-and-turn test, that the test does begin when the instructions are given. Now, when a test may differ based on the type of test. For example, the reciting the alphabet or standing on one foot, those tests may begin at different points. But this court did state that for a walk-and-turn test, the test begins when instructions were given. And I think the fact that the trooper placed the defendant in the starting position with one foot in front of another, it was more than him just standing on the sidewalk, but he was actually placed in a particular fashion and in a way that obviously made it difficult for him to maintain his balance, as evinced by the fact that he stumbled, shows that that the test had begun, that the trooper had affirmatively placed him in this position, told him how to stand, how to position his feet, and then the defendant was unable to maintain that position.
Okay, so if the defendant were placed in the position for the walk and turn, and the trooper here is giving the instructions, and he said quite clearly, "I don't want to do this test," is that a refusal?
I believe that if it was that clear an expression, then yes, that would be a refusal, but that is not what happened in this case.
Well, let's pause, because I'm afraid your learned colleague may have been too kind on the burden of proof, because the Commonwealth is offering this fellow's performance, and he has the constitutional right not to make statements. And so the issue is, who had the burden of proof on the withdrawal of consent? And do you have a case?
Well, I would agree that this was the defendant's motion in limine, and the proffers made when the motion was heard.
That can't possibly be dispositive, because a lot of times a motion in limine is that the Commonwealth can't meet its constitutional obligation to prove that the search was proper or that the statements were voluntary, and the burden is still on the Commonwealth. So that can't be the test, right?
Sure. Yes, Your Honor. I do not have a case, but I would note that based on the transcript and what Trooper Page did testify to, that this case would fall under Brown and would fall under Gregson, and that these statements are not clear refusals, but rather are the expressions of difficulty in completing the test.
When we're talking about the trooper's testimony or just testimony, we're talking about testimony that came out during the trial, correct?
Yes, Your Honor.
So how are we taking that into account in consideration of the motion in limine?
Well, Your Honor, both parties made proffers when the judge was hearing the motion in limine, but the defense did not raise any objection during the testimony. And in fact, the testimony was consistent with the proffers that each of the parties made. They were referencing the police report, and Trooper Page's testimony did deviate slightly from the police report in that he elaborated on more of the statements that the defendant had made.
Evaluating the correctness of the judge's decision at the time the judge made the decision, aren't we limited to the information that was in front of the judge at that time? How do we look ahead?
Well, the judge is limited to what they hear in the proffer, but the testimony was consistent with what was proffered, and the defense did not re-raise any objection to the testimony that came in at trial.
Let's go back on that though, because the transcript on the motion in limine was, this is how I think the evidence is going to come in at trial, Judge, that he refused. And if that's how the evidence comes in, then I think you have to exclude this. And then that's arguably how the evidence came in. And yet up until now, until this very moment, the Commonwealth had said this issue was preserved. I'm not so clear now what the Commonwealth is saying, at least as to the trial testimony. Do you think we can't look at the trial testimony?
No, I do believe we can look at the trial testimony because it is consistent with what was proffered and because it still supports the judge's finding. The judge found that this was not refusal testimony, and
Did the judge find that though? I'm a little not following you on the representations and the proffers, because it seems like the ADA overstated his case. The police report doesn't say much, or maybe I've missed it and you could point it to me, about the defendant making any statements. And so it seems like the defense attorneys raised his concern, and then the ADA didn't know what the officer was going to say. And then the trooper elaborated a lot, much more than what was in the police report.
Well, Your Honor, transcript page 9, in his proffer, the Commonwealth stated, he references the police report. He states that the officer asked the defendant to test, that he got him into the starting position, and he attempts to start doing the test. The Commonwealth did not note the statements that the defendant made. And it was based on the fact, obviously the judge was noted that the defendant had agreed to test, but the Commonwealth did note that he was placed into the starting position and had attempted the test, and that's when the statements came in. So the judge was correct to rule that that was not refusal evidence, but rather was the expression of difficulty because the defendant had started the test when he was placed in the position.
Either because the ADA didn't know what the witness was going to testify to, or however it happened. During the motion in limine, nobody told the judge that there were statements that were made. It was all, he got him in the starting position. But there wasn't, you can point me to the transcript and line numbers, but I don't see that the judge was told that the statements were made, and that's the whole issue.
Correct. However, the defense attorney did note on page 8 that the defendant started shaking his head. So he did testify to the fact that he did proffer that the defendant was shaking his head, which,
and do you think shaking his head has to be this, and that up and down, I'm giving a visual here, is nodding, and that this is shaking?
I believe in this context.
Do you think there's ambiguity?
I believe there's ambiguity, Your Honor, especially in this case, in this context.
Now, the defendant says, though, he had a vigorous defense and he knew his license was suspended and he knew he was in jeopardy of arrest because of the suspended license. And so he really was, I can't believe I'm in this situation, shaking his head.
Correct. And we would argue that there is still ambiguity there. Trooper Page testified to numerous observations that he made of the defendant, that he was stumbling, that when he got out of the car, he had to hold onto the car for support, that he fell backwards into the car. So
there was definitely other evidence here.
Yes, but it is a reasonable inference that the shaking of his head was not communicative, but was rather a product of his intoxication. And that's why he was shaking his head. And I would like.
How do we make all these? I have the same question for you that I had for your brother. How are we to make these inferences, reconcile the discrepancies, and reach the factual conclusions that you're asking us to reach about what the shaking of his head signifies?
Well, Your Honor, I would direct your attention to footnote 2 of Gregson, where this court did note, and as you noted, Your Honor, that the context is what matters. And here, I think the transcript makes the context clear.
The problem is that these ambiguities that we're talking about needed to be resolved by the trial judge or the motion judge, and we don't have a resolution of them, do we?
I believe that they are clear. It shows that the defendant attempted the test. He was attempted to stand in a position with one foot in front of the other. He stumbled. He could not maintain the position. He was pacing around and muttering incoherent statements, in which he then muttered something to the effect of, "I can't," or "I don't want to," statements like that, which in context, as this court noted in Gregson, show that these were statements of expressions of his difficulty to complete the test and not refusals.
Sure. So let's say for a moment that even if we were to agree with you that all of those were permissible conclusions based on the totality of the circumstances, but that we disagree that we are the proper forum to make those inferences in the first instance. In your view, in the Commonwealth's view, what is the proper remedy here? Is it a remand? And if it's a remand for what?
I do not believe a remand is the I believe the record is clear, and I do believe this court can make.
But I'm asking you to, for the moment, not to concede, but to assume that we disagree with you. Okay, just assume that we say, no, we can't decide this in the first instance ourselves. What would be the Commonwealth's requested relief?
If the court is not accepting or just wishes, a remand could be possible. However, Trooper Page testified to his observations of the defendant.
I understand that. We're talking about a lack of findings. The factual record is what the factual record is. Just no one made any findings about it. So we don't make findings here at the appeals court. So what would be the remedy in your view?
Then if the trial judge could rehear the motion and perhaps hear more than was proffered at trial and make a more detailed finding, rather than just noting that the defendant agreed to test, but rather taking into account the fact that he had attempted the test, and then the statements followed the fact that he had already attempted the test.
What happens to the conviction in the meantime?
Well, Your Honor, even if this court finds that these statements were refusal, or perhaps if the trial judge then does find that these statements are refusal, the admission of the evidence was harmless, was a harmless error, and there was overwhelming evidence of the defendant's intoxication for the jury to hear. So I believe that the conviction would still be upheld on that fact. And there are 9 key facts that indicate his intoxication, including his erratic driving, the observations that the officer made of his slurred speech, his glossy eyes, his observations of the defendant stumbling, and finally the inventory search of his car, which revealed 6 empty liquor bottles near the driver's seat. I see my time
your time has expired, but so I apologize, but I don't remember you giving us a case on the burden of proof, and we know defense counsel didn't give us a case on the burden of proof, and it seems like that is a potentially dispository issue.
Your Honor, I do not know a case off the top of my head, but I am happy to look into it and provide it via 16L letter.
I think it might be helpful if you each submit a letter. We don't want argument in this letter. We understand the arguments. You just give us, within the meaning of Rule 16L, which just asks for the authority you're relying on the question of the burden of proof on the withdrawal of consent.
Yes, Your Honor.
Thank you. And maybe you could do that. How's a week sound? All right.
That would be fine.
Absolutely, Your Honor. Thank you.
Perfect. And you'll file that through our electronic system, please. And are there any further questions from the panel? No, thank you. Thank you both. It's an interesting case. We've certainly been helped by your argument, and the case is submitted.
Thank you all.
Thank you, Your Honors.